Welcome and thank you for standing by. At this time, all participants are on a listen-only mode until the question and answer session of today's conference. At that time, to ask a question, press star 1 on your phone and record your name at the prompt. Today's call is being recorded. If you have any objections, you may disconnect at this time. I would now like to turn the call over to Yvette Reddick. Thank you. You may begin.
Welcome, everyone. I'm Yvette Reddick and the Director of the Division of Policy and Training at the Office of Child Support Enforcement. And on behalf of Commissioner Scott Leakin, who couldn't be with us today, I'm very pleased to welcome all of you to the second webinar in the 6-part training series on interstate case processing. We've developed these trainings for you, our state partners, and hope you will find the webinars and the training resources useful. We know that interstate case processing can be one of the most challenging areas of our work. We see it on questions all the time in the Division of Policy. We had over 1,000 people register for the very first conference on Interstate 101 back in July. And we've had a really similar response for this webinar with almost 800 that we can tell. We really appreciate that many of you have gathered in groups to participate, which really helps us to save resources. I can say that the leadership at OCSC was so impressed to have so many people on our webinars to learn about Interstate. On a personal note, we almost canceled the webinar, but decided to go forth because at least in D.C. we're not getting hit as hard as we thought we would with Hurricane Florence. But I do want to mention that we are thinking about our colleagues and everyone who's affected by Hurricane Florence, and that our thoughts are with them. For those, we may, if there's enough interest, we might do this webinar again for those people who could not join us. Before I turn over to our presenters for today's webinar, Diane Potts and Jeanette Savoy, I want to really thank you for the opportunity, for the hard work that you do every day in serving families in the child support program. Please let us know how OCSC can further support you. And now I will turn you over to Diane and Jeanette. Diane?
Thank you, Yvette. I also want to thank everyone who participated in the Interstate 101 training, with a special thanks to those who responded to the post-webinar evaluation. Many people submitted questions during the Interstate 101 training and on the evaluation mentioned the need for more time for questions. We're continuing at OCSC to draft responses to the questions that were raised during the last training, and we'll get back to those individuals as soon as possible. For today's training, we'll do our best to address participants' questions. If you submit a question through WebEx, please submit the question through the Q&A feature to all panelists located on the right hand of your screen. Due to the tremendous turnout for this training, we most likely will not get to all the questions. If you have a question that's not answered today, you'll be able to submit a question directly to OCSC after the webinar on the email address listed on the final slide, and OCSC will respond. This also will help us if we need to get clarification on the question. Okay, without further ado, welcome to Interstate 201 training. This training is on interstate child support case processing with an in-depth look at federal laws, federal regulations, and the Uniform Interstate Family Support Act, which is referred to as UIFSA. Interstate 201 is more advanced interstate training and has several companion courses on interstate case processing, including Interstate 101 training with basic materials on the laws and processes for interstate cases, interstate case scenarios, interstate payment processing, interstate case closure, and interstate tools and resources. All of these trainings focus on interstate cases and are intended to complement, rather than repeat, OCSC's training on the revised intergovernmental forms and international case processing. Please note that in some instances, UIFSA provides different rules for international cases. In this training, we're first going to look at interstate case processing and registering an order for enforcement, including defenses to registration. We'll then turn to the special evidentiary rules for interstate cases. We also will discuss which states' laws apply in interstate cases, direct income withholding, and the impact of modifying another state's order. At the end of the training, there's a list of the references used in this training, including UIFSA, with hyperlinks to the electronic version of the documents. We use the term parent throughout these trainings because most child support cases involve two parents. It's important to recognize, however, that some child support cases may not have two parents, such as when there's a guardian for the child or a foster care agency is seeking support. So even though we use the term parent, the same interstate rules will apply to cases when it's not the actual parent of the child pursuing support. Also, this training will use the terms custodial parent and non-custodial parent, but OCSC recognizes that there are cases where the parents have shared custody. OCSC also recognizes that the non-custodial parent is sometimes the applicant. For simplicity, this training will assume that the custodial parent is the applicant in our scenarios, unless otherwise specified. And now I'll turn it over to Jeanette.
Thanks, Diane, and hello, everyone. So let's get started with interstate case processing, which will provide a good opportunity to review the terms and core concepts that we learned in Interstate 101 training and to put those terms and concepts into action. We will cover how to gather information, what facts are relevant in interstate cases, and the different options that child support caseworkers have in working interstate cases. There are two ways interstate cases can become a part of your IV-D caseload. The first is where a parent is receiving IV-D services in your state and the other parent resides in a different state. These cases do not come through your central registry. Instead, your IV-D agency receives the case after the parent applies or is referred for services. Your IV-D agency is considered the initiating agency because it is responsible for initiating an action, such as one-state remedies like direct income withholding, or a two-state referral of an interstate case. Your IV-D agency will need to know the relevant facts and what options are available to determine the most appropriate course of action to take in the case. We will talk about investigating the facts of cases, available interstate communication tools, and initiating agency options. The other origin for an interstate case is where a parent has applied for services in another state, and that state sends an interstate IV-D case to your state. This type of interstate case comes to your central registry, and your IV-D agency is the responding agency responsible for taking action based on the requests of the initiating agency. In the next few slides, we will look at a few cases in the first category of interstate cases, namely where the parent is receiving services from your IV-D agency. The parent applying for services need not be a resident of your state. Instead, a non-resident parent may apply directly to your IV-D agency for services. Federal regulations require states to accept applications for services. Within 20 calendar days of receiving either an application or a referral from another agency, the IV-D agency must open a case, establish a case record, and solicit necessary and relevant information from the parent applying for services and from other relevant sources. Relevant information includes determining whether there's a support order that's already been issued, either in your state or another state, and whether any state has an open IV-D case. The IV-D agency must also investigate where the non-custodial parent resides. If the IV-D agency determines that the other parent resides in another state, the agency then must determine whether it should use one-state remedies for establishment or enforcement, or whether the agency should refer an interstate IV-D case to the state where the other parent lives. It's the responsibility of the initiating agency to select the best case processing approach given the facts of the case. Now I'll turn it back over to Diane.
Thanks, Jeanette. Cooperation among states in interstate child support enforcement is required for 40 agencies and really critical to the success of the child support program. OCSE has provided states with interstate communication tools to facilitate cooperation in interstate cases. All state 40 agencies have the Child Support Enforcement Network, or CISNET, which allows child support professionals to exchange child support information electronically among the 54 states and territories. CISNET was designed to improve intergovernmental case processing in many ways, including allowing states to receive matches from the Federal Case Registry, or FCR, containing case and participant information. The FCR contains information for 40 and non-4D cases and serves as a pointer system to assist with case processing. Data on parents in the FCR is matched daily against employment data in the National Directory of New Hires and sent to states to facilitate case processing and increase collections, especially through automated income withholding. These matches can be used for all facets of case processing. Query Interstate Cases for Kids, or QUIC, is an optional online communication tool for states. QUIC offers child support professionals secure, real-time access to financial and case activity information for cases in other states participating in QUIC. A child support professional may also use the Electronic Document Exchange, or EDE, to request case documents from or send documents to the other state electronically instead of sending documents through the mail. To request information from another state that the child support caseworker can't find independently using interstate tools, the worker should use the Limited Services option on the Child Support Enforcement Transmittal Number 3, Request for Assistance Discovery. When the 4D agency learns that the noncustodial parent lives in another state and there's no support order, the agency may use one-state remedies to establish a support order only if long-arm jurisdiction over the noncustodial parent is present. As indicated in the Interstate 101 training, UIFSA provides several bases for long-arm jurisdiction. There are substantial benefits to a state exercising long-arm jurisdiction when the facts establish that the noncustodial parent had the required contact with the state, and we'll review these benefits in the Choice of Law section of this training. If long-arm jurisdiction is not present or it's not appropriate based on the facts of the case, the 4D agency will refer an interstate 4D case for establishment to the state where the noncustodial parent resides. If the 4D agency learns that a support order has been established, but there's no paying income withholding order, the agency may search for an employer for the noncustodial parent. If an employer is located, it may send a direct income withholding order to the employer. Under UIFSA, a state does not need to have personal jurisdiction over the noncustodial parent to collect income earned in another state by sending a direct income withholding order. UIFSA does require, however, that the direct income withholding order contain all of the terms set forth in the issuing state's child support order, including the amount of support and payment location. The other option is to refer an Interstate 4D case to the state where the noncustodial parent resides for enforcement of the order.
To practice the concepts of investigating and processing an interstate case where the custodial parent has applied for services, let's take a look at a hypothetical case. Here, the custodial parent and child are in Nebraska and have applied there for child support services. The custodial parent tells the caseworker that the non-custodial parent resides in Missouri. What must the Nebraska 4D agency do under federal regulations? Remember that, as Diane mentioned before, federal regulations require that the Nebraska IV-D agency open a case, establish a record, solicit additional information from the custodial parent and other sources, determine whether there's a support order in another state, and investigate whether the non-custodial parent lives in a different state. Ultimately, the IV-D agency must determine whether one-state remedies or referral of an interstate case is appropriate. Let's use the same hypothetical case with the custodial parent in Nebraska and the non-custodial parent in Missouri to practice investigating an interstate case. In order to fulfill the requirements, the federal requirements for this case, what facts does the Nebraska caseworker need to know in order to determine whether the use of one-state remedies or referral of an interstate IV-D case is most appropriate for this case? What interstate communication tools are available? And finally, what are the options for processing this case? In order to fulfill those federal requirements, you must approach your case like an investigation to determine the relevant facts using available tools and resources, and ultimately decide on the best case processing option. The first relevant question is whether parentage or a support order has been established. If parentage or support has not been established, the child support caseworker needs to know whether the non-custodial parent is subject to long-arm jurisdiction in Nebraska. States may use the FCR to establish whether an order exists for a child in another state. If they get an FCR match, they can use QUIC to get additional information about the other state's case. If Nebraska has long-arm jurisdiction, the caseworker should consider using one-state remedies to establish a support order or parentage. If long-arm jurisdiction is not available or appropriate, an interstate IV-D case for establishment should then be referred to the IV-D agency in the non-custodial parent state, in this case, Missouri.
Let's say there is a support order. If so, the child support caseworker needs information about that order, including where it was issued, the terms of the order, and whether that state that issued the order or any other state has an open IV-D case. The caseworker can answer most of these questions by using the interstate communication tools, SESNET and QUIC, or by accessing information from the FCR. The caseworker can get a copy of the order by sending the request through EDE, that's the quickest method, or by sending an intergovernmental transmittal number 3, request for assistance discovery, to the state that issued the order, either through SESNET or by mail. There also is information on the Intergovernmental Referral Guide, commonly called the IRG, question J25, about how to obtain a certified order. The caseworker also needs to investigate whether there is a paying income withholding order, meaning that there are child support payments currently being withheld by the non-custodial parent's employer. If there is a paying income withholding order, the IV-D agency providing services to the custodial parent may be able to simply request payment forwarding from the state collecting support. Payment forwarding is explained in greater detail in the companion training, Interstate Payment Processing. If there is no paying income withholding order, the child support caseworker should determine whether an employer for the non-custodial parent can be located. If so, direct income withholding should be considered. If another state has an open IV-D case, the caseworker must coordinate enforcement with that IV-D agency to avoid duplicative income withholding notices. If an employer cannot be located, the caseworker should refer an interstate IV-D case to the non-custodial parent state for enforcement.
So we've talked so far about cases where your agency is providing services to a parent. Remember, however, that your IV-D agency also will have Interstate Cases as a responding agency. These interstate cases are sent from an initiating agency to the central registry of the responding agency. In most cases, the responding agency will be the state where the noncustodial parent lives, but sometimes an Interstate IV-D case is sent to a state where the noncustodial parent has assets, such as property or a bank account. We discussed the required forms for Interstate IV-D cases in Interstate 101 training, and OCSE has a more in-depth training on the 2017 intergovernmental forms on its website. A matrix listing all the relevant forms to use in specific interstate actions is also available on the OCSE website, and hyperlinks to both the matrix and the forms training are provided at the end of this training. Federal regulations require the Central Registry to do the following within 10 working days. They must review the case and confirm the presence of all required intergovernmental forms. They must send the acknowledgement of receiving the case and request any missing documents from the initiating agency. Also, within the same 10 working days from receiving the Interstate IV-D case, the Central Registry must send the case for location services if the noncustodial parent's address is not known, or send the case to the appropriate local office if the noncustodial parent's address is known, and inform the initiating agency where the case was sent. Even if there are missing documents, the Central Registry cannot reject the case. Instead, it must forward the case on for any action that can be taken while the initiating agency gathers the additional documents. For example, if the child's birth certificate is needed but missing from the referral and the noncustodial parent's address is unknown, the Central Registry must request the birth certificate from the initiating agency and also send the case to its state parent locator service. The role of the responding agency is to accept and process an Interstate IV-D case and to provide all necessary services just as it would in an intrastate case. Federal regulations require the responding agency to provide these services regardless of whether the initiating agency elected not to use remedies that might be available under the law of its state, including those one-state remedies. The intrastate services that a responding agency must provide include establishing parentage if needed, and establishing a support order if needed, sending an income withholding notice to the noncustodial parent's employer, monitoring compliance with the support order, sending payments to the initiating agency's SDU, identifying and collecting any arrears through income withholding, and any other enforcement actions needed.
So the responding agency is responsible for making the decision on whether to process the case using administrative actions, such as income withholding, without registering the order for enforcement, or to register the order with the tribunal for enforcement. Even if the responding agency initially decides to pursue administrative enforcement of the order, it always has the option to register the order later if administrative enforcement is ineffective or if additional enforcement tools available to a tribunal, such as civil contempt, are necessary. If it locates an employer for the noncustodial parent, the responding agency may decide to use administrative enforcement without registration by sending its income withholding notice to the employer. In addition to income withholding, the responding agency may use any administrative remedy available in its state, such as a bank lien or driver's license suspension. The only exception is that the initiating agency, not the responding agency, is responsible for submitting the case for federal tax refund offset. UIFSA permits the noncustodial parent to contest the withholding by registering the income withholding order and filing a contest with a tribunal. The non-custodial parent also may challenge the validity of the other state's order or administrative enforcement, and UIFSA requires the responding agency to register the order with the tribunal for further proceedings. We'll look at registering orders and the requirements for contests in interstate cases in the next training topic, registration for enforcement. In some cases, the enforcement of child support across state lines might have an unintended consequence of putting a party or child at risk of family violence. UIFSA provides a mechanism that preserves confidentiality of personally identifiable information where there's a risk of family violence or child abduction in an Interstate IV-D case. A party must allege in an affidavit or a pleading under oath that the health, safety, or liberty of a party or child would be jeopardized by the disclosure of specific identifying information. The IV-D agency checks the non-disclosure box on the appropriate intergovernmental forms, such as the Personal Information Form for UIFSA Section 311, or the letter of transmittal requesting registration, and attaches the affidavit or pleading. All identifying information is sealed and not disclosed to the other party or the public. After a hearing in which the court takes into consideration the health, safety, or liberty of the party or child, the tribunal may order disclosure of information that the tribunal determines to be in the interest of justice. We've covered interstate cases as the initiating agency and cases as the responding agency, but it's important to know that there are services that are federally mandated where your IV-D agency is neither an initiating nor responding agency. Federal regulations require IV-D agencies to perform certain limited services when requested by another IV-D agency without opening an interstate case. These are quick locate, service of process, assistance with discovery and genetic testing, teleconferenced hearings, administrative reviews, high-volume automated administrative enforcement, and copies of court orders and payment records. Requests for other limited services may be honored at the requested IV-D agency's option. All limited services requests, mandatory or discretionary, are made on the Child Support Enforcement Transmittal Number 3, Request for Assistance Discovery. Limited services can be a very effective tool in interstate case processing. Therefore, it's important to work together to take full advantage of these requests.
Next, we're going to look at interstate IV-D cases after the responding agency registers an order for enforcement with the tribunal. This section will include the basics of registration and what is required, contests to registration, and enforcement after registration. UIFSA uses the term tribunal to include a court, administrative agency, or quasi-judicial entity authorized to establish, enforce, or modify support orders, or to determine parentage of a child. In most states, the tribunal that hears interstate child support cases is a court, and will use both terms, tribunal and court, interchangeably throughout this training. As explained earlier, the responding agency has the option when it receives an interstate IV-D case of registering the out-of-state order with the tribunal. Under UIFSA, the registration process is the mechanism to get the order before the tribunal for enforcement. In most cases, the tribunal will be the court in the county where the non-custodial parent resides. Also remember that UIFSA allows registration of an out-of-state order for enforcement or modification or both. In this section of this training, we're focusing just on registering an order for enforcement. Under UIFSA, anyone may register an out-of-state order with a tribunal, including either parent and the child support agency. An order is deemed to be registered once it's filed, even though a non-registering party has a limited period to contest the registration. The registering tribunal must recognize and enforce the support order unless it vacates or stays the registration. The tribunal cannot modify the order. This follows the one order at a time UIFSA rule. The registered order does not become an order of the tribunal that registered it, but it continues to be an order of the tribunal that issued it. But the registered order is enforceable in the same manner, using the same procedures as an order issued by the tribunal of a registering state. If the noncustodial parent does not properly and timely contest the registration, the order is then confirmed by operation of law.
When an order in an interstate case is registered with a tribunal, UIFSA requires notification to the non-registering party, and a copy of the registered order must be provided to the party. The notice serves to inform the non-registering party of the registration and that there's a limited time frame to request a hearing to contest the validity of the registered order. The notice also must inform the noncustodial parent of the amount of the arrears being alleged and that not contesting the order will result in confirmation of the order. The time frame to file a contest to the registration of an out-of-state order is limited by state law. UIFSA suggests a 20-day time frame, but allows states the option to select a longer or shorter time frame. Note that for intergovernmental cases involving an order from a Hague Convention country, the time frame is longer. The contest must be filed with the registering tribunal. If a contest is filed, the tribunal must schedule the case for a hearing and provide notice of the hearing to the parties. The responding agency must inform the initiating agency of the hearing in case they have additional information that may help resolve the contest or in case the other parent wants to participate in the hearing. We'll look next at the type of contest allowed under UIFSA and the limited defenses to registration of an out-of-state order. A party challenging a registration may be seeking to vacate the registration altogether or may have a defense as to why they're not complying with the support order. A party also may challenge a specific part of the registration, such as one or more of the remedies sought, or may disagree with the amount of past due support being alleged by the party registering the order.
UIFSA lists the types of defenses that a party may raise to registration of an out-of-state order. These defenses include that the tribunal issued the order lacked personal jurisdiction over a parent. The term personal jurisdiction means the tribunal's authority to make decisions and take action against the parent. If the issuing tribunal did not have personal jurisdiction over a non-custodial parent, the child support order may be set aside by the issuing tribunal or the registering tribunal. Other defenses to registration are that the order was obtained by fraud, the order is no longer in force because it's been vacated, suspended, or modified by a subsequent order, that the issuing tribunal has stayed the order pending appeal, and to continue, defenses under state law to the remedy sought by the registration. The parent has made full or partial payment of the alleged arrears. Collection on some or all of the arrears is barred by a statute of limitations, and the order is not the controlling order in the case. UIFSA's list of defenses to the registration of an out-of-state order is limited, and complaints about an order outside of the list are not valid defenses to the registration. Frequently, a non-custodial parent may believe that the support order is too high or that a judgment for arrears was not calculated correctly. The parent may also claim that he's not the biological parent of the child and should not have to pay support. These issues, however, cannot be raised in the registering tribunal. Instead, the parent must seek relief and make those claims in the issuing tribunal.
So let's see how well you understand registration by practicing with a scenario. Here, the non-custodial parent resides in Kansas, and the custodial parent and child live in Illinois. Illinois issued a support order. The Illinois IV-D agency sends an Interstate IV-D case to Kansas, requesting enforcement of its order. The Kansas IV-D agency registers the Illinois order with the court in the county where the non-custodial parent resides, and that parent is notified of the registration on May 1st. The first question concerns when the contest must be filed. Under most state laws and the time frame suggested in UIFSA, the non-custodial parent has 20 days after receiving notice to file a contest with the registering tribunal. In our hypothetical case, the non-custodial parent would have until May 21st to file the contest. The second question involves the valid defenses to the registration for enforcement. Answers 1, 3, and 5 are valid defenses. The non-registering party may assert that there have been payments on the arrears, the parent was not subject to the jurisdiction of the tribunal in the establishment case, and the child support order had been modified. Answers 2, 4, and 6 are non-valid defenses. The non-registering party may not assert that the issuing tribunal miscalculated the arrears in the judgment, the child support order was set too high, or the non-custodial parent is not the genetic father of the child.
In every contest, the burden is on the party contesting their registration to prove a valid defense. For example, if the non-custodial parent is claiming that there were payments made that are not reflected in the arrears balance alleged in the notice of registration, the parent must prove to the court that those payments were made. If the court finds that the parent has provided proof of a valid defense, the court has the power to stay enforcement of the order, continue the proceeding for additional relevant evidence, and issue other appropriate orders. However, if the parent has not provided proof of a valid defense, the court must confirm the out-of-state order. If the order is confirmed, either by operation of law because no contest was filed, or if the court confirms the order because there's no proof of a valid defense, then the order cannot be further contested on the basis of any of the defenses listed in UIFSA. Once an out-of-state order is registered, the tribunal will enforce the order as if it were an intrastate order. This slide and the next slide lists the specific enforcement actions set forth in UIFSA that the court can take depending on state law. Those enforcement remedies might include ordering the parent to comply, issuing an income withholding order, determining if additional arrearages have accrued since registration and ordering payment of those arrearages, enforcing the order by civil or criminal contempt. They also include setting aside property, like a bank account or car, to satisfy the support order, placing a lien against real property, like the non-custodial parent's home, and ordering the sale of that property to satisfy arrearages. The court may also order the parent to provide notification of any change in contact or employment information and issue a warrant or body attachment against the parent for failing to appear for court. Finally, the tribunal may order the non-custodial parent to search for employment, pay reasonable attorney's fees, and grant any other remedy available under the law in the responding state. The court may not condition payment of support on whether the custodial parent complies with the parenting time order. Although many interstate cases involve pro se or unrepresented parents, UIFSA allows either parent to be represented by a private attorney.
So let's use a hypothetical case to practice using enforcement principles. Missouri sends an Interstate IV-D case for enforcement of its order to Iowa. The Iowa IV-D agency registers the Missouri order with the court in the county where the noncustodial parent resides. The Iowa IV-D agency provides notice of the registration to the noncustodial parent. If the noncustodial parent does not contest the registration, or if their contest is unsuccessful and the registration is confirmed by the court, which of the following is prohibited under UIFSA? The answer is number 2. The court may not reduce the child support amount. The rest of the answers are permissible actions. The court may fine the noncustodial parent in civil contempt for not paying support, issue an income withholding order, or order the noncustodial parent to search for employment. So we're more than halfway through our training today. Yay! Before we move on to rules of evidence, we're going to look for questions about the topics that we've covered so far. Operator, if you can go ahead and open the phone lines and give some instructions to folks to get through.
Thank you. To ask a question, please unmute your phone, press star 1, and when prompted, record your name clearly so I may introduce you. If you wish to withdraw your question at any time, press star 2. Again, to ask a question, press star 1. It may take a few moments for questions to come in. Please stand by.
And while we're waiting for some questions to come in over the phone lines, we do have a question on the WebEx. We have a question from Gianna. What is considered a valid notice? And I'm assuming you're talking about the notice that has to be sent of registration of an order for enforcement. And that's going to be governed by Section 605 of UIFSA. That's going to set forth all the requirements that have to be in that notice, including that the notice must inform the non-registering party that the registered support order is enforceable as of the date of registration in the same manner as an order issued by a tribunal of this state, that a hearing to contest the validity or enforcement of the registered order must be requested within a certain number of days after notice, and that failure to contest the validity or enforcement of the registered order in a timely manner will result in confirmation of the order and enforcement of the order in alleged arrears and of the amount of the alleged arrears. So thank you so much for that question. Operator, do we have any questions on the phone line?
Yes, our first question is from Renee Layton. Your line is open.
I have an order that I registered from another state. I'm wondering if, since it has been registered, can we proceed with criminal non-support on this case?
That is an excellent question, Renee. If it has been properly registered and it has not been contested and it has the full force and effect of law, and you can use intrastate remedies just as if it was an interstate case. I don't know the particulars of your law in your state, but if you've got criminal non-support as an enforcement tool that you can use in your state, then it would be available in an interstate case.
Thank you.
And our next question comes from Daniel Pruitt. Your line is open.
Yes, our question stems from in a responding state, can that responding state obtain an order towards the arrears payment on the past due child support? Or modify an existing order of only on the arrears, not to do with current support?
Mm-hmm. So, Jeanette, you want to take the first stab at that question?
Sure. So you're asking if a court can order a specific monthly arrears payment?
Yes, that's correct.
I think I would look at that as a modification. So if you have not been, especially when you talked about modifying the order, if you're really modifying the order, unless their order has been registered for modification and your state has CEJ or could obtain CEJ, then I'd say you wouldn't do an order for it. But you certainly can enforce on those arrears, and you can set the agency can set an expected reasonable arrears payment.
Okay, so not necessarily an arrears payment from a court order, but we can expect it from the noncustodial parent.
Certainly. Most orders really, when they begin, don't have arrears, right? So, as they accrue, then the agencies enforcing need to determine, and many states have a sort of a set formula for how they determine what arrears payment will be made. Diane, would you have anything to add to that?
Yeah, I agree, Jeanette. I think it depends on the order that comes over to your state for enforcement. If it's already got a set judgment on the arrears and arrears payment that was set by the initiating tribunal, then you should just enforce that. You should not modify that order. But if it comes over with perhaps just a judgment amount but no payment on that, I believe it would be my best advice would be I think that would be okay, because you'd want to get support payments on that arrears if the noncustodial parent has got that ability to make those arrears payments in addition to current support. Yeah, go ahead.
So I'm confused. So we should obtain a judicial order for the arrears. Let's say we get we start working a case, the arrears build up. There's a zero order on the arrears piece. We should obtain a judicial order for that.
So that's a very good question. I think we are going to do due diligence. I think we know the answer, but I think we're going to get back to you on that, if that's okay.
That'd be fantastic. Thank you.
Okay, absolutely. So we do have a question on WebEx that I want to take. And this is from Stephen. If we need a copy of an order terminating parental rights from another state's local tribunal, how would we request that through EDE? Jeanette, do you have some thoughts on that?
Well, I think there might be somebody from the federal office on who would have the list, but I'm not sure that that's a listed form that you can request. If it is, and the other state participates and will send that form, you can certainly send the request. Otherwise, you might be able to request it using a transmittal 3.
So, hey, Jeanette, this is Carrie. So the answer to the question is that the way that EDE works is that you can obtain a copy of an order or a certified copy of an order. It doesn't get down into whether it's the termination of parental rights. So what I would recommend is to try to use EDE to request that order if there's an order out there, because, again, it doesn't specify whether it has to be a child support order. It just says a court order.
Thanks, Carrie, for that advice. Thank you very much. So we're at 12:50, and we want to make sure we have enough time to get through the rest of the presentation, but we should have a good amount of time at the end for additional questions, both through the operator lines and through WebEx. So keep them coming. Thanks so much. Those were really great questions. So I'm going to turn it over to the next slide for Jeanette to open us up with rules of evidence.
So now we are going to look at UIFSA's special rules of evidence and how they apply to tribunal proceedings in interstate cases. UIFSA has special rules of evidence and procedure to address the unique evidentiary challenges in interstate child support establishment and enforcement by incorporating modern methods for gathering and submitting relevant evidence to a tribunal. You should be aware of these rules, even if you're not an attorney, because parents involved in interstate cases may have questions related to these issues. First, the tribunal cannot require the physical presence of a non-resident parent in interstate cases. The tribunal must permit any party or witness who does not reside in the state to testify by telephone, audiovisual means such as Skype, or other electronic means. UIFSA also provides rules on the admission of documents in interstate cases. A party who resides out of state may submit an affidavit, a document substantially complying with federally mandated forms, and other documents as evidence if sworn to under penalty of perjury. Examples include an affidavit or tax return submitted to the court under penalty of perjury as proof of income in a child support establishment case. Certified payment records are also admissible as proof of payments that have been made by the non-custodial parent. As long as the document would not be excluded on hearsay grounds if given in person, the tribunal must accept the document as admissible as evidence. UIFSA also provides that a certified copy of a voluntary acknowledgement of paternity is admissible to prove parentage of a child. On April 26 of 2018, OCSE issued PIQ 1801 to provide further clarification on electronic evidence in interstate cases. Specifically, OCSE clarified that tribunals may not exclude an electronic document with a signature just on the basis that the signature is not an original. OCSE also explained in PIQ 1801 that the special UIFSA rules do not distinguish between certified copies of support orders required by UIFSA for enforcement or modification and other types of documentary evidence. Therefore, tribunals may not exclude an electronically transmitted certified copy of an order from evidence based solely on the fact that it was transmitted electronically. PIQ 1801 is listed with a hyperlink at the end of this training. If the document's authenticity is challenged, however, the tribunal may then require a party to produce the original document or other evidence of the document's authenticity. UIFSA provides that the petitioner in an interstate case will not be required to pay a filing fee or other costs. Remember that either parent or the IV-D agency can be a petitioner in an interstate case. Costs and fees may be assessed by the tribunal against the non-custodial parent if the custodial parent prevails, including filing fees, reasonable attorney's fees, and other costs, and necessary travel expenses incurred by the custodial parent or witnesses. The tribunal must order the payment of costs and reasonable attorney's fees if it determines that a hearing was requested primarily to delay the case. That will be the presumption if, in a registration proceeding, a hearing is requested and the registered support order is confirmed or enforced without change.
So in this next hypothetical case, Nebraska initiates an Interstate IV-D case for enforcement of its support order to Illinois, where the non-custodial parent resides. Illinois registers the Nebraska order, and the order is confirmed by operation of law. Later, a hearing is set for the court to address the non-custodial parent's failure to pay child support. Here are some questions to practice using interstate evidentiary rules. First, can the court require the non-custodial parent to appear? Yep, the court can require the non-custodial parent to appear because he's a resident of Illinois. Second, can the court require the custodial parent to appear? No, the court cannot require the custodial parent to appear because she's not a resident of Illinois. Third, can the court refuse to consider an electronic copy of a certified child support order because it was transmitted through EDE? No, the court cannot refuse to consider any document based on the method of transmission alone. Finally, can the court rely on the certified payment record as proof of the non-custodial parent's payment history? Yes, UIFSA permits the court to accept the certified payment record as evidence of the non-custodial parent's payments. So let's move on to choice of law principles for different types of establishment and enforcement cases. In the following section devoted to modification, we're going to cover choice of law principles for modification cases because they're a bit more complicated. The phrase choice of law is a legal term that simply refers to the choice of which state's law applies in a given case or to a particular issue. For interstate cases where parents reside in different states, UIFSA's choice of law principles dictate which state laws apply in the case. Sometimes the applicable state law will depend on whether the court is deciding a substantive issue, like the amount of child support, or the duration of the support obligation, or whether it's a procedural issue, such as proper service for the noncustodial parent, or filing a contest to the registration of an out-of-state order. Even for non-attorneys, choice of law principles are important to know and consider when handling interstate child support cases.
When a court establishes a support or parentage order, or both, the court applies the laws of its state to both the substantive and procedural issues. Therefore, if a court is ruling on a petition to establish parentage and genetic tests reveal a probability of paternity, the court will apply its state laws in adjudicating paternity, including whether the probability of paternity in the case creates a presumption under that state's law. For support establishment, the court will apply its state's child support guidelines to the facts of the case in setting support. The laws of that state will also apply to whether and how much retroactive support is ordered in the case. Finally, the issuing state's laws set the duration of support, which can range from 18 years to over 21 years of age. The court will also apply its procedural rules in the case. For example, if state law or the court's rules provide for how genetic testing is scheduled or costs allocated, those laws and rules would apply in the case. Similarly, if the noncustodial parent fails to appear for court, the court's rules on default will apply. Remember that the tribunal establishing an order in an interstate case will vary depending on whether one state or two state remedies are used. The law of the initiating state will apply if the tribunal uses long-arm jurisdiction to assert jurisdiction over the noncustodial parent. On the other hand, if the IV-D agency providing services to the custodial parent refers an Interstate IV-D case to the agency in the noncustodial parent state for establishment, then the tribunal in the noncustodial parent state will apply its substantive and procedural laws to the case.
After a support order is established, the issuing state's law will control all aspects of that order going forward. This means that even if the parents move to different states, the issuing state's law will govern the amount and duration of the current support payments and the interest that accrues on unpaid support. In addition, the tribunal that issued the order will ultimately be responsible for determining the amount of arrears and whether the noncustodial parent has satisfied the support order. When a court is enforcing another state's order, the court must abide by the terms of the order and apply the law of the order issuing state for all substantive issues, such as the amount of support, interest and penalties for arrearages, and length of the support obligation. However, UIFSA provides that the court may apply its procedural rules to the enforcement case. For example, a court will apply its rules regarding entering a default order or bench warrant and its procedures for a civil contempt action. The court also will apply its laws regarding the types of enforcement remedies that are available to compel payments on a child support order. The comments to UIFSA explain that if the order issuing state has enacted a wide variety of license suspension statutes, while the responding state has a much narrower list of licenses subject to suspension, local law in the responding state prevails. If the responding agency is enforcing the order, it must abide by the same choice of law rules as the court. In most states, there's a time limit called a statute of limitations on how long someone can continue to collect a money judgment. In child support, when a tribunal is enforcing another state's order, Questions may arise on how long a state can continue to collect past due support, which is a money judgment by operation of law. UIFSA provides that the choice of law for statutes of limitations in interstate cases depends on which state has the longer limitations period, the issuing state or the responding state. For example, let's assume Texas is the issuing state and has a 10-year statute of limitations. If Vermont is the responding state enforcing the Texas order and it has a 20-year statute of limitations, Vermont's law would apply in that case. The converse is also true. If Vermont, as the issuing state, has a 20-year statute of limitations, and Texas, as the responding state, has a 10-year statute of limitations, Texas must apply Vermont's statute of limitations. Texas must continue to collect the arrearage owed on the case beyond the 10 years provided in its law. So to practice choice of law concepts, let's take a look at a hypothetical case. Here, an Iowa court issued a child support order for current support and a judgment for arrears. Iowa sends an Interstate IV-D case to Kansas for enforcement of its order. The first question is, what law governs the duration of child support? Under UIFSA, Iowa's law will decide how long the noncustodial parent must pay current support. Iowa issued the original support order, so Iowa law controls duration. The second question is, what law governs civil contempt proceedings brought against the noncustodial parent? The Kansas court will apply its procedural laws and rules to the contempt hearing. Finally, what law determines the statute of limitations for collecting the arrearage owed by the noncustodial parent? Well, it depends. If Iowa's law provides for a longer statute of limitations, its law will apply in Kansas. If Kansas's statute of limitations is longer, Kansas law will determine how long the Kansas IV-D agency may continue to collect the arrearage.
We're down to our last two topics in this training, so let's look briefly at direct income withholding next, including the applicable state laws that employers must follow. As we learned in Interstate 101, UIFSA requires an employer to treat an income withholding order sent from another state that is regular on its face as if it had been issued by a tribunal in the employer state. OCSE has explained that regular on its face means that any reasonable person would think that the income withholding order is valid. This occurs when the order is payable to the state disbursement unit, the amount to withhold is a dollar amount, the text of the OMB approved form has not been changed, and the OMB form number is listed on the form, and the order contains all of the necessary information to process the income withholding order. The hyperlink to OCSE's guidance on direct income withholding is listed at the end of this training. If the income withholding order meets those standards, employers must comply with the order's terms, including withholding current support, withholding any payments ordered on the arrearages, and any provision requiring health insurance coverage or the withholding of cash medical support, up to the applicable limits set by the Consumer Credit Protection Act or by state law.
UIFSA requires the employer that is complying with an out-of-state income withholding order to follow the laws of the state of the parent's principal place of employment for the amount that the employer can charge to process the withholding. The law of the state where the parent is employed also governs the maximum amount that may be deducted from an employee's paycheck. While the Consumer Credit Protection Act sets the maximum amount for withholding, some states have laws that set the maximum withholding at a lower percentage of the noncustodial parent's income. UIFSA also provides that the law in the state where the parent is employed will apply to the times for implementing withholding and forwarding payments. But please note that federal regulations set a 7-business-day time frame for employers to remit payments after they're withheld from a non-custodial parent's paycheck. UIFSA and federal regulations specify that the law of the employer's state applies when determining priorities for withholding when there are multiple income withholding orders, at least one being out of state. Federal regulations also provide that the state law of the employer applies to any withholding term or condition not specified in the withholding order. It's important to note that for employers who do business in several states, the relevant test under both UIFSA and federal regulations is the state where the non-custodial parent has their principal place of employment. So to practice the concepts of direct income withholding, let's take a look at a hypothetical. Here, a Kansas tribunal issued a child support order that includes a provision for the non-custodial parent to carry health insurance. The Kansas IV-D agency locates an employer for the non-custodial parent in Iowa and sends a direct income withholding notice. The first question is what law governs how much the employer must withhold. Under both UIFSA and federal regulations, the employer must withhold the amount specified on the income withholding notice, including amounts for repayment of arrearages and interest, unless the amount would exceed the maximum amount allowed under the Federal Consumer Credit Protection Act or the law in the employer's state. So in our example, the employer must withhold the support indicated on the withholding notice unless the Consumer Credit Protection Act or the law in Iowa requires a lower amount. The second question is what law governs the fee that the employer may charge to process the withholding. Under both UIFSA and federal regulations, the employer will apply the law in the state where the parent works to determine what, if anything, the employer may charge the non-custodial parent to process the withholding notice. The last question is what law will apply to an order for an employer to provide health insurance. Like the first question, the employer is required to comply with the terms of the Kansas order, including any provision for the employee to cover their dependents on employer-provided health insurance.
The last topic for this Interstate 201 training is modification. We covered the basics on modification in our Interstate 101 training, and now we're going to do a deeper dive into modification issues that often arise in interstate cases. As we learned in Interstate 101, there are 4 basic rules in UIFSA that govern when a state has jurisdiction to modify an order of another state in an interstate case. The first modification rule is if either parent or the child lives in the issuing state, modification can only occur in the issuing state. The issuing state retains CEJ, and no other state will have the authority to modify the order. The only exception to this rule is when the parents consent to another state modifying the order and assuming CEJ, so long as the consent is filed in a record with the issuing tribunal and the state assuming CEJ has personal jurisdiction over at least one of the parties or is the state where the child resides. This might occur, for example, if only the child lives in the issuing state and the parents both live in the same different state from the issuing state. The second UIFSA modification rule is that if the parents and child now live in states other than the issuing state, modification cannot occur in the issuing state. The issuing state no longer has CEJ to modify the order. Again, there's an exception, and the only exception is if the parents consent in a record or in open court for the tribunal of the issuing state to retain CEJ to modify its order. This might occur, for example, if the parents divorced in the issuing state and there are ongoing spousal support issues that need to be addressed in the issuing tribunal. The parents may want to continue to address child support issues there as well. The third modification rule applies when the parents move out of the initiating state and now live in the same state and the child does not live in the issuing state. In that case, the new state where the parents live may register and modify the order. Once the order is modified, that state becomes the issuing state and assumes CEJ for any future modification. The final but very important UIFSA modification rule is the play-away rule. It applies when neither the parents nor child live in the issuing state and the parents live in different states. When that occurs, the parent who wants the modification must seek modification in a state with personal jurisdiction over the other parent, which usually means seeking registration and modification in the non-requesting parent's state of residence.
So a tribunal with modification authority may modify the amount of current child support according to its guidelines. It also may determine the amount of past due support owed by the noncustodial parent from the point of modification on. Finally, the tribunal will apply its law related to interest on past due support going forward. So there are also some terms of the original order that are non-modifiable. UIFSA states that a tribunal of this state may not modify any aspect of a child support order that may not be modified under the law of the issuing state, including the duration of the obligation of support. One aspect of the order that a court cannot modify relates to the arrears and interest that accrued prior to the modification. But another aspect involves certain provisions tied to the original issuing state's law, including duration of support, which is how long the current support is due. Duration of support is established by the law of the original issuing state, and that law always applies, regardless of how many other states modify the order and assume continuing exclusive jurisdiction over the life of the case. In most cases, this means that the duration of support is set by the original order. In rare circumstances, however, a state may modify the duration, but only if it's allowed by the original order state's law. So, for example, assume the original order state's law requires payment until the child is 18 years of age. In most cases, support will terminate at age 18, regardless of subsequent modifications of the order. However, if the original order state's law allows a party to petition for support to continue beyond age 18 if the child is incapacitated, a responding tribunal with jurisdiction to modify the original order may similarly extend support upon petition and proof of the child's incapacitation by applying the original order state's law. The amount of support ordered, however, will be governed by the responding state's law. So what happens when a court modifies another state's order in violation of one of UIFSA's rules governing modification jurisdiction? Well, courts are divided on this issue. Some courts have concluded that UIFSA's modification rules establish subject matter jurisdiction, which is the court's general authority to hear and decide a particular type of case under the state's constitution. Any order issued without subject matter jurisdiction is a nullity from the outset, which means that the prior order remains in effect in interstate cases. Other courts have held that while the court was not permitted under UIFSA to modify the order, the court still had subject matter jurisdiction under the state's constitution to hear and decide a child support case. These courts have concluded that any order issued in violation of UIFSA's modification rules is a mistake of law that must be brought to the court's attention by a party within a limited time period. There may be cases in which you learn that there is an original order entered in compliance with UIFSA in one state and a subsequent order entered in another state for the same non-custodial parent and child in violation of UIFSA's modification rules. It's important for states to work together to correct this situation. If you believe the court issuing the subsequent order did not have the authority to do so under UIFSA, it's important for the 4D agency to ask the court to rule on the validity of the subsequent order. This is a determination that the court must make, not a child support caseworker or attorney. The important point here is that the non-custodial parent cannot be obligated for current child support more than once for a child.
Now let's practice using those modification principles with a few scenarios. Here, the custodial parent and child are in Kansas and have applied for child support services. The non-custodial parent resides in Nebraska, and the order was entered in Illinois. If Kansas sends an Interstate IV-D case to Nebraska for registration and modification of the Illinois order, what can Nebraska modify on the Illinois order? A tribunal in Nebraska will have the authority to modify the amount of current support. Further, once the court in Nebraska modifies the order and assumes continuing exclusive jurisdiction, the law in Nebraska will determine the interest that accrues going forward on any arrearages under the modified order.
So using the same scenario, what are some of the terms of the Illinois order that the court in Nebraska cannot modify? Under UIFSA, the court cannot modify the duration of the child support established by Illinois law unless expressly permitted by Illinois law. Therefore, the non-custodial parent must pay support until the child is 19 years old, pursuant to Illinois law, regardless of the law in Nebraska. Also, any arrearage that accrued under the Illinois order will not be modifiable in Nebraska, but any past due support that accrues after modification will be governed by Nebraska law, including interest on the arrears. So we have a few minutes for some questions on interstate modification or any topic covered today, but I first want to point out that after the webinar, all registrants will receive a training evaluation. We hope you will complete it, and you are also welcome to include any additional question in the evaluation response. You also can send questions to OCSE at the email address listed on the slide. So let's take a couple of minutes. Operator, if you can instruct folks on how they should dial in for some phone line questions, and we'll also have time to take some questions from WebEx.
Thank you. Again, if you would like to ask a question, press *1, unmute your phone, and record your name clearly when prompted so I may introduce you. *2 to withdraw your question. Again, *1 to ask a question. Our first question comes from Patricia Zimmerman. Your line is open.
Hello.
Hi. Yes,
I have a question on how to get another responding state to forward money directly to distributing central, our SDU, because they keep sending it directly to us.
Mm-hmm. Okay, so I'm just trying to make sure I understand. You are the initiating state, and you've asked a responding state in a two-state case to enforce a support order, and they're doing that, but they're not sending the payments to your SDU.
No. Yep, that's correct.
Okay. So I think that's a problem. I would go ahead and contact your regional OCSE staff. The federal regulations do require that a responding state send payments to an initiating state within, I believe it's 7 business days. So I would, a lot of times that can be effective is involving your regional unit. I'm assuming that you've already contacted that other state and they are, they're still refusing to send it to your SDU?
Right.
Okay. Yeah, I would bring it up to the regional level. Jeanette, do you have any additional thoughts on that problem?
No, I would say the same thing. I think there's probably just something in the responding state system that they need to correct. Almost every state sends payments electronically, so there may just be a little glitch in that case where they need to fix where the payments are going. But certainly your regional office should be able to help you with that.
Okay, thank you.
Thanks, Patricia. So, operator, I'm going to take one question on the WebEx, and that's from Carrie, and she wants to know, is the statute of limitations information in the IRG or in writing anywhere? And your answer is yes, it is. It's in Section E of the IRG, and there's 4 questions listed, or 3 questions listed in there, including what's your state statute of limitations for collection of past due support, and what's your state statute of limitations for paternity establishment, and then there's 2 other follow-up questions on that. So thank you for submitting that question through WebEx. And I have one other question I'm going to take on the WebEx before we go back to the phone lines, and it's from Claudia, and it's, does interest continue to accrue for the 20 years per Vermont statute of limitations? This goes back to the hypothetical in which Vermont has assumed CEJ, it has modified the support order, and it has the longer statute of limitations. So as long as the arrearage is outstanding, Vermont, with CEJ, its law on interest is going to apply in that case, and it will be applied to the arrearages that have accrued under that order. So thank you, Claudia, for that question. Anything from the phone lines, operator?
Our next question comes from Brenda Urbanski. Your line is open.
Well, my question was about the statute of limitations. So I missed that, what she was saying. Can you tell me where I can find that at again?
Absolutely, Brenda. So it is in Section E of the IRG. And it's got, and it's got the specific question, what's your state statute of limitations for collection of past due support?
Okay, thank you.
Okay.
Yep.
Do we have a next question, operator?
Our next question comes from Linda. Your line is open.
Hi, I have a central registry question because I noticed you were stating that central registry has like 10 days to process the packet. But when you're having other states refusing to accept your packet because they're wanting additional information, what can you do about that? I've had several initiating UIFSA packets being refused to accept them because they wanted some additional information.
Okay, good question. Jeanette, do you have any thoughts on that?
Sure, I'll take that one because I was the manager of the Central Registry in Colorado for many years. A Central Registry cannot refuse a case because a document or information is missing. But they are required by federal law to process the case as far as it is possible with the information that's provided. So they can't just tell you, no, we're turning it back. They have to continue to work it. Now, they may need it before they can go too much further, but rejection is not an option. And if that continues to happen, again, I would talk to your regional OCSE rep.
All right, thank you.
Thanks, Jeanette. So let me take a question from WebEx, and this is from Shannon. Shannon wants to know what's the suggested time frame for the local agency to take the first action on a new UIFSA received from Central Registry. And the answer is, under the federal regs, it's 75 days from receipt of the initial documents from the Central Registry to provide some initial services. They're all going to be listed in the federal regulation, which is 45 CFR 303.7, and it's under D2. We've got a hyperlink, I believe, to that section, but we're happy to provide you with that statute if you need additional information. So thank you so much for that question. Operator, do we have any more on the phone?
Yes, we have 4 more at this time, and our next question comes from Casey Cole. Your line is open.
Hi, thank you. Our question is also in regards to the statute of limitations, choice of law. Does the responding state need to register the issuing state's order in order to apply the longer statute of limitations?
Wow, that's a great question, Casey. I want to say no, but I am going to have to do some checking on that because it's a legal principle. I may be mistaken in my initial reaction of no. So if it's okay, I'm going to follow up with you on that question.
Yeah, that'd be great. Thanks.
Okay.
And our next question is from Karen Labareri. Your line is open.
Yes, this is a reference to the modification. I just want to know, is there anywhere that states that we as a 4D agency, as a courtesy, we assist the client with filing a modification? If we're the responding state and the order is here for enforcement only, so we will have to send it out to another state to assist them with their application. But do you know if there's anywhere that is noted that as a courtesy that we assist that party in reference to filing their modification?
Okay, so I'm going to need to ask some follow-up questions, Karen, on that one. So we've got a 3-state case, I'm assuming. So initiating state where the order was entered is sending a case over for enforcement to you guys, and the non-custodial parent does the non-custodial parent still reside in the issuing state or reside in a 3rd state?
Okay, the non-custodial parent resides in the state of New Jersey, and it's a Florida order, and we're sending it to Georgia just to modify it. Mm-hmm. So we're enforcing. Yes, I'm making myself clear. Yes, we're the enforcing state. I'm sorry. Yes, we're the enforcing state, and we're sending it to the other state to register it for modification only.
Yeah. In order to make sure that we absolutely answer your question correctly, since it involves so many states, can I ask you to submit that in writing so that if we need follow-up clarification, we can get that from you?
Okay. Can I ask you just one question under the oath where you said for non-disclosure? Is that oath you're referring to where they have to go to court, or it's just because I understood the non-disclosure form that they can just use the non-disclosure form if they say that they feel harm or, some type of, will happen if the other person got their information?
Jeanette, do you know the answer to that question?
Sure. In the 1996 version of UIFSA, it required a court finding of nondisclosure. In the 2008 version, it only requires the affidavit. As soon as the affidavit is received, then nondisclosure is in effect unless one of the parties asks for a hearing and the court orders disclosure. Does that answer your question?
Yes.
Okay. And when you submit the other question, could you make sure you say who is requesting the modification?
Sure.
Thanks.
Thank you.
Yeah, I agree, Jeanette. I would just add one more point that for the nondisclosure, I think the court, certainly in majority cases, it's going to be a request by the noncustodial parent to have a hearing that would, in order for the court to release the disclosure of the identifying information. I agree with you that you just need to attach the affidavit or the pleading, but I think under UIFSA 2008, it leaves open the possibility that a court on its own may want a hearing, but I think that's so rare that that's not going to occur in 99% of the cases. So I think that that's absolutely correct. So why don't we are almost out of, actually we're out of time, so I want to cover the last couple of slides which provide you with really valuable hyperlinks. Jeanette, you want to talk about the hyperlinks?
Yeah, we're not going to talk about them too much, just that you can take these hyperlinks to get to the UIFSA 2008 or the Intergovernmental forms matrix or forms training. And then the next slide goes to that PIQ that we talked about with the electronic documents and also the income withholding answers to employers.
Thanks, Jeanette. So this concludes our Interstate 201 training. We have 4 more Interstate training sessions for you in October and November this year and January and February of next year. Registration for these events will be available 2 to 3 weeks prior to the dates listed on the slide, and we really hope you'll join us for these trainings as well. Finally, as some of you have asked on WebEx, OCSE will be posting the recordings and the PowerPoints, including trainer notes from all these sessions on the OCSE website for your future use and to share with colleagues who may not have been able to attend any of these sessions. So thank you so much for attending Interstate 201 and have a great afternoon, everyone.
And this concludes today's conference. Thank you for participating. You may disconnect at this time. Speakers, please stand by for post-conference.